Good morning, everyone. I'm very glad to welcome you to this public forum being held by the Africa Center for Open Governance and Kenyans for Peace with Truth and Justice. That's AfriCOG and KPTJ. And we want to thank you very much for making your way to be with us. Welcome, Heshimiwa. I don't use that term lightly, by the way. So we're very happy to be joined by you. This is the second in a series of events that we're going to have around the issues which arose from the recent election. As civil society, we've been reflecting on what this really means for us and our work. We had a very good session about a week ago exactly, where we looked at the global context of civil society and the local context. We looked at the changes around the world. We saw that the situation in Kenya with increasing authoritarianism, flawed elections, and the usual things that go along with that, and an atmosphere of public polarization, an atmosphere where it seems impossible to have discussions on an objective basis, an atmosphere where, any truth, everybody's truth is the truth, and lies are the truth, and the truth becomes lies. This is not only characteristic of Kenya. It's happening around the world. I only need to say the name Donald Trump, and that will tell you quite a bit. So we looked at our situation in this developing context, and were trying to be self-critical about the way we work, the way we have worked, and what that means. What the apparent failure to communicate with the public and to agree with the public about values, the values we've been pushing for so many decades: human rights, free and fair elections, equality, gender equality, anti-corruption, ethics in leadership, etc. We see when we look at the elections and the kind of people who get voted in, that doesn't seem to matter very much to the public, or perhaps they simply are acting in a context where they have no choice, so they're making choiceless choices. We will continue because this was a very deep reflection, and it needs to be expanded and taken around the country, and we want people to be able to discuss and debate. So what we're doing today is we're looking at the 2022 elections, and we're looking at them through the lens of the Supreme Court process and decision. Just let me interrupt for a minute. I hope Betty or Carol, are you on, and your people? We were hoping to be joined by a group in Kisumu and some people in Migori. I hope they've got the link. If not, will somebody please share the new link with Betty or Carol? Yeah? You can. Thanks, Winnie. And I hope Gabriel Dolan has been able to share the new link. Okay, so what we're doing today is looking at the results of the impact of the Supreme Court process, the way it was managed, and the decision that came out of it. Through the lens of the Supreme Court decision itself, we'll analyze the decision and look at its context and impact. And we'll also have a presentation on the scrutiny of the IEBC technology that was ordered by the court. So this will be the report of the experts, technical experts, hired by petitioners in petition E003 of 2022, Khalif Khalifa, and George Osewe Mumbi, Ruth Mumbi, and Grace. Grace? Kamau. Thank you very much, Kwamchetsi. So these technical experts represented the petitioners in E003. As you know, all the petitions were consolidated, and a few were not allowed, but those that were allowed were consolidated into one. So we aim to stimulate conversations around the elections because we know there's a deep public need for it. The Supreme Court decision left the country polarized, with those who, quote unquote, won, although I don't know what it is, they think they won, and those who, quote unquote, lost, totally on, in irreconcilable positions, apparently. So we'll begin with a presentation from Wachira Maina, well-known constitutional lawyer and governance expert. He's going to take us through his analysis of the decision of the Supreme Court 2022, compare it to previous decisions, contextualize it against other decisions in the region, for example, the Malawi judgment, and tell us what he thinks this portends for this country. And after Wachira, Dr. Jim Otieno will speak to us about the results of the outcomes of the scrutiny of the technology at the IEBC as conducted by him and his team for the petitioners in E003. And what we're asking here is what does this mean? What do these events and outcomes mean for going forward? How will this impact on the 2027 elections? How does it impact on the legitimacy of the institutions, the two main institutions involved in the running and decision of presidential elections anyway? The IEBC, for our foreign guests, that's the independent electoral, IEBC, Independent Electoral and Boundaries Commission, the electoral management body, and the Supreme Court, for our foreign listeners, the Supreme Court is the only instance, the first and last instance where petitions against the outcomes and conduct of the presidential elections are decided. So that makes them extremely important in this process. They have the first and last word in this case. Well, perhaps not the last word, but in terms of the judgment, there's no overturning it. So they upheld the very contentiously announced decision by Chairman Chebukati, and so therefore that stands. But that does not stop us from discussing the quality of their judgment and the quality of the procedure that they led. The quality of the scrutiny that was conducted under the Deputy Registrar of the Court. That does not stop us from commenting. It does not stop us from criticizing. It does not stop us from praising anything that we find that's positive. But as far as the Supreme Court is concerned, they have spoken. So therefore, there's no need for them to be speaking at funerals or anywhere else. They're supposed to speak through their judgment, and they have spoken. So one of the worries of the results of this process is what is the impact on the legitimacy of these institutions, and indeed on their cohesion as institutions, and perhaps even continued existence. Can we go into, and for the rule of law, can we go into the next elections with these institutions configured as they are, and with the process of elections configured as they are? Or do we have to start discussing some very deep changes? Or will we see a risk where people, as they did in this election, vote with their feet and basically not participate in the process? As you know, the president was elected by a minority of the registered voters, and it was an extremely narrow result. So there's a legitimacy deficit which one notices in the sort of nervousness about criticism and the sort of aggressive approach to any sort of opposition. Yes, so there we are, polarized, half of the country deeply disturbed, the other half defiantly arrogant, the institutions threatened, the institutions under threat, as we've seen with the current process of the quote-unquote removal of the quote-unquote rogue commissioners by a purported by a purported legal process, a tribunal. So we're here to discuss today what all that means for us, and I'm very happy to welcome you. And during the session, as you can see from your programs, we will be launching a report on the scrutiny of the technology, which you'll be able to take home with you and study the results of. It's not yet available. Don't get nervous. We'll distribute it when it gets launched just shortly before the closing. So with those words, I would like to thank you all for coming, and I would like now to invite my good friend Wachira to come and enlighten us.
Thank you, everyone. Thank you, Gladwell, and good morning, everyone. The title of my presentation is, Can Anyone Ever Prove that an Election in Kenya is Invalid? A comparative analysis of the legal issues raised by the 2022 presidential petition. Now, my presentation has 7 parts. I will not go into all of them in any real detail, but those parts, the first part is context. I want to set the context by referring back to what lessons the court or the IEBC might have learned from previous elections. And then I want to frame some constitutional questions that I think we need to worry about. I then will look at legal issues around electoral technology. I will then talk about some more technical questions of a legal nature, like burden and standard of proof. Then I will revisit an issue that has had a second airing in this petition. That is a question of votes cast versus valid votes cast. And then another question that has reared its head once again is a question of illegalities and irregularities. And then I have some final thoughts. Now, let me begin with the context. What are the lessons that IEBC and the Supreme Court may have learned about elections from 2013 and 2017? And I begin by saying the most important lesson, it seems to me, is that the court and the IEBC may have learned the benefits of unanimity. The lessons from 2013, when the court was unanimous, and the lessons from 2017, when it was not unanimous, and then the lessons from 2013 and 2017 for the IEBC, when it was unanimous, and 2022, when it was not unanimous. The lessons that we can see are the following. First, in 2017, a divided court was told, we shall revisit. There was an explicit threat issued by the political class, and the effect immediately after the election was not just a reduction in funding, it was active defunding of the judiciary. This was not just for judiciary, it's anybody who was perceived then to be against the government, including the Kenya National Commission on Human Rights, the Office of the Auditor General, and to some extent the Commission on Revenue Allocation, were all defunded. The first, a unanimous court in 2022, the first order of business was to fund them, provide the funding that had in some ways been held back. So that unanimity has a political premium. No problems for IEBC in 2013, no problems in 2017. In fact, those who bungled the 2013 election through procurement, corruption, and also through Chickengate were given a sweetheart deal in 2016. I was part of those reforms, so I do know this for a fact. I'm not speculating. that they were given a sweetheart deal to leave their positions. Now, the 4 commissioners who left after 2017, and those who have left on the eve of the announcement of the result in 2022, have faced serious political recriminations. In other words, dissenters invariably have a problem, whether they're in the IEBC or in the judiciary. Now, that's the first general proposition about the context. The second general proposition about the context is nullification of a presidential election in Kenya is a lose-lose proposition in Kenya. First, it has no immediate benefits for the court. The court is left holding the can, and the petitioner might just ride into the sunset with the nullification in his pocket. In 2017, we saw after the nullification, the principal petitioner refused to participate in the runoff, in the second election. In effect, you have a nullification in which the supposed party at whose behest the nullification was done walks into the sunset. The Supreme Court is then, in its own analysis, left holding the can in the sense that the nullification is to no purpose, if you see what I mean. The contrast with Malawi is quite interesting here, because in the Chilima case, after the nullification, there was a rerun of the election, and all the parties participated in it. So the nullification, in that sense, wasn't a lose proposition for the court. So far as the country is concerned, the country gains nothing, other than the pride of being the only country in Africa in which the court has the balls to nullify a presidential election, as it was at the time. Okay? In the medium and long term, the political and financial cost to the judiciary is not offset by the legitimacy gains conferred by a decision to nullify. In other words, if you think about it, what does the Supreme Court gain? If there is no rerun, in other words, if the country is going to an election, and the country has gone into an election, there is a cost of running that election, and if the people at whose behest notification was done, if they don't participate in that election, really, the only gain the court has is a legitimacy gain, the gain that you have the balls to nullify an election. So that the court then can do a cost-benefit analysis and say to itself, the cost we bear for nullifying is not offset by the legitimacy we gain by nullifying. Now, picture the court's position in 2022, confronted with that history. It is in this position. First, it has the same head petitioner, Raila Odinga, of course this time with Honorable Martha Karua, as it had in 2013 and 2017. To some extent, it has the same issues before it. The same problems of opacity, the same allegations of possible corruption and fraud and interference, and the same request for scrutiny of the technology. It's got basically a whole host of issues that are quite similar. And the question we have to ask ourselves really is, did these factors play any role in the way the court approached the determination of the 2022 petition? Now, consider the following. First, in 2017, the court ordered a very expansive scrutiny, even though in 2022, there was actually more prima facie evidence of wrongdoing than there was in 2017. What was the prima facie evidence in 2022 that was not there in 2017? One, there was an audit of the register of voters by KPMG in 2017, which came too late to either influence the election or to influence the decision of the Supreme Court. But that audit had shown that the register was in complete disarray and was vulnerable to all manner of attacks. So that was first available, this was available in full in 2022. There was a DCI investigation into the Venezuelans, which showed that there was a fairly high-level attempt to influence the election, and that Smartmatic did not have a good record elsewhere. Number three, there was a repeat audit of the register of voters in 2022, which showed many of the weaknesses disclosed by the 2017 audit, indicating that in the intervening 5 years between 2017 and 2022, IEBC had done nothing or very little to fix the database vulnerabilities. So then you have to ask, given these factors, why was the court so restrictive in ordering the scrutiny that it did in 2022? In 2017, again, The court read IEBC's attempt to restrict access to its databases against it. It actually described IEBC's failure to comply fully with its order as contumacious disobedience of its orders. In 2022, however, the Supreme Court disbelieved any factual claims that were made by virtually all the petitioners and believed most, if not all, of the factual claims made by the IEBC without explaining the basis of coming to this conclusion, systematic disbelief of one side and systematic belief on the other side. Including, for example, the affidavits sworn by the dissenting commissioners who were privy to what had been going on inside IEBC and who are in a majority. So I think, for me, the first issue I have to ask myself is, did this context play any role in the decision of the court? First, in the decision of whether they were unanimous, and secondly, in the attitude that the court, through its quite robust negative comments to the petitioners in 2022. So that is the first set of issues, contextual issues. Then I want to raise some constitutional questions. This is the second part of my presentation. Now, I want to draw your attention to the Constitution. The Supreme Court has only two areas in which it has original jurisdiction. The first one is whether a petition to challenge the election of the president-elect the decision relating to a petition to challenge the election of the president-elect, and then giving advisory opinions. Those are the only two issues on which the Supreme Court has original jurisdiction. This raises a really important question that I have not had lawyers ask. So what happens if constitutional questions arise which are not part of the original jurisdiction of the Supreme Court during the hearing of a presidential petition? What does a court do if a constitutional question is raised? The Supreme Court doesn't have original jurisdiction on constitutional questions. That jurisdiction is in the High Court. But supposing a constitutional question is raised, as it was in this petition, the Supreme Court, what should the Supreme Court do? Now, let's first of all remind ourselves which issues the court set out for a resolution in this petition. Those questions were the technology used, interference with forms to the portal, discrepancy between uploaded Form 34As and 34As received at the National Tallying Center, effect of postponement of gubernatorial elections, discrepancy between presidential and other votes, verification, whether verification complied with the Constitution. This was actually the only constitutional question that was raised by the issues framed by the Supreme Court. And number 7, the president-elect's winning threshold, the effect of illegalities and irregularities on the result, and then what relevant reliefs should the court offer. Now, the most important thing is there was one killer question. And that killer question was actually a constitutional question. In fact, it is recognized in the judgment of the court in paragraph 3. It says, at the heart of this consolidated presidential petition are contestations around one question: whether IEBC complied with the constitutional and legal standards in the conduct of the presidential election held on 9th August 2022. And in 30 paragraphs, from paragraph 214 to paragraph 244, the court itself is explicit that it is engaged in interpretation of the meaning and application of Article 138. In other words, it is engaged in the meaning and application of a provision of the Constitution, a matter on which it does not have original jurisdiction. It explains what it is doing in the following terms. The court must therefore interpret and settle the meaning, scope, and application of Article 138, 3, C, and 10 of the Constitution. In other words, it recognizes that the case has raised doubts as to the meaning of those provisions. Now, what is the constitutional problem here? What is the court to do when it is confronted by an issue on which it does not have original jurisdiction, and yet it is adopting the stance that it has to interpret and settle the meaning and scope and application of that provision. It is not a matter on which it has original jurisdiction. So this matter has not been ventilated and settled and discussed in the High Court, in the Court of Appeal, and before it comes finally to the Supreme Court. Now, this issue had arisen peripherally in two previous cases. One of them was the BBI case, and the other one was Michael Sistu Kamau versus Ethics and Anti-Corruption Commission. That related to the Anti-Corruption Commission. And in those two cases, the issue of the scope of Section 1, the scope of powers related to a constitutional commission had not been fully ventilated by the parties. In other words, this issue has never gotten a hearing in any court. So although the court had decided in both cases that the decision of 3 commissioners could not be impugned in both cases, the reason for making that decision was not based on a hearing of the parties. It was based on two things. First, the 3 commissioners who had acted after the 4 other commissioners had resigned had acted pursuant to a declaratory finding of the High Court. In other words, the High Court had given them permission to act. And it would be wrong to say that the decision of the 3 commissioners was illegitimate when the 3 commissioners believed they were acting pursuant to a court order. In other words, the question itself was not settled about the scope of the powers of a commission under Section 138. Yeah? So, how should the court approach the question of constitutional interpretation, especially knowing that the interpretation the Supreme Court places on this issue will be binding on other courts? Yeah? So the options open to the court are the following. Option 1, the Supreme Court should make a narrow, non-binding finding whose purpose is limited to disposing the question whether the result of the announcement of a winner in the election was lawful. And it should make it clear that this finding is non-binding on other courts. That is not what the court has done here. It has gone out to interpret, apply, and settle the question. Number 2, what's going on? Okay. Number 2, the second option open to the court. The second option open to the court is to stop the inquiry into the constitutional question altogether and dispose of the petition without having to settle the constitutional question. This would have been complicated in this particular case because the issue was at the heart of the dispute. But this is the problem, because the court is settling an issue which it hasn't had parties on. That's a fundamental wrong in this finding. Number 3, the court could also stop the proceedings and refer the issue back to the High Court for full litigation. This was possible. This is technically possible, but it would have required the Supreme Court to read into the Constitution new timelines because of the timelines that are set for pre-listening to a presidential petition. And I want to finesse this argument because I think it is important to understand what I'm saying. When a court is given original jurisdiction of a matter, it means you cannot raise that issue in any other court other than the court that has original jurisdiction. When a court has appellate jurisdiction on a matter, you cannot go straight to that court which has appellate jurisdiction and litigate the issue there. You must first of all litigate it in the court that has original jurisdiction, and then work your way to the top. Now, obviously, if the court were to stop the proceedings so that it can refer the issue back to the High Court for the purposes of fresh litigation, of course, the timelines in the Constitution for hearing of a presidential petition would go through the window. Now, this is not as unreasonable as it sounds, because one possibility is to say, how does the court read those timelines? There are 2 ways of approaching this question. For example, let me say 2 things that address both the constitutional question and the timeline question. The constitutional question, in Malawi, in the High Court, when the petition was filed, the court decided that the petition was raising constitutional questions because under ordinary circumstances, the court would be able to hear a petition, but a court would not hear a petition unless it had at least 3 judges to hear the constitutional question. So the Malawi High Court framed constitutional questions and sent them to the Supreme Court of Appeal and asked the Supreme Court of Appeal to certify that those were the constitutional questions. So in the end, the Chilima decision, the decision I'm referring to, did not proceed technically as a petition. It proceeded as an interpretation of the Constitution. So it wasn't really a petition in the technical sense. It was a constitutional reference. Please don't push it down because I'll then not be able to read my computer. So that it proceeded as this. So this was a constitutional question. What that does is to change the procedure that is available to the court. The procedure of petition no longer applies, and the procedure for constitutional petition applies. Now, how about reading into the Constitution new language that allows the timelines to be open? Now, let me say a few words about the doctrine of reading in. The Constitution, there are some approaches that have been taken to deal with defective language. Sometimes, if you had asked the people who drafted the Constitution of Kenya, supposing an issue of constitutional interpretation arises when the Supreme Court is hearing an election petition, would you have preferred the Supreme Court to decide that question, though it has no original jurisdiction on it, or do you have preferred to freeze the petition and refer the issue back to trial at the High Court? I do not know what answer they would have returned. But clearly what we are faced with here is a potential for an absurdity or the potential for overreach by the Supreme Court dealing with questions it ought not to be dealing with as a matter of original jurisdiction. So some courts have resolved this problem in interesting ways. In South Africa, they have the jurisprudence around reading in, reading out, reading down. Yeah? In other words, you can't read into the Constitution or into any law, but they haven't done this with the Constitution yet. They do this with statutes. You can read into statute some words that allow the statute to be constitutional. And in fact, we've got some cases. First of all, I think we need to warn ourselves that this is a power that should be used very, very sparingly. That you do not want to tell the court to be reading into the Constitution, because then it raises separation of powers issues. Because then what you have is the risk that the court will start reading into the laws, anything it wishes, and discretion goes galloping away into the night, and you don't know where it will end up. But if you've got a genuine problem, then you've got to ask yourself, what is the court to do? And the court, the Constitutional Court of South Africa warned in a case called Gatner, that it is important that this power be used sparingly because the actual act of writing or editing legislation may constitute a possible encroachment by the judiciary or the terrain of the legislature, and therefore a violation of the separation of powers. Nonetheless, the option exists, and it's constitutionally permissible. And more important, in our case, the Supreme Court has read out of the Constitution language, explicit language in the Constitution, the provision related to votes cast. The court added valid votes cast. It actually read into the Constitution. It added valid votes cast. The drafters of the Constitution didn't say valid votes cast. They said votes cast. But the Supreme Court read into it valid votes cast. And I'll show you why that is a problem when I come down to discussing that question. So, in the case of Provincial Minister for Local Government, Environmental Affairs and Development Planning of Western Cape versus Municipal Council of Oudtshoorn Municipality in South Africa in 2015, the court adopted a paragraph that read into statute the following words: other than a matter mentioned in section 162 of the Constitution. So it added those words to the statute to make the statute compliant with the Constitution. Now, and it said that this was legitimate because the constitutional invalidity of the provision in the statute was attributable to omission of words which could be included without impermissibly traversing the legislative terrain. And number two, the language of the impugned provision appeared to be an inadvertent error. And number three, there were no other options available to cure the unconstitutionality. And the question here is, what were there other options available for the Supreme Court to act without assuming original jurisdiction on a matter relating to interpretation of the Constitution? And we can debate the merits and demerits of this argument as we go along. Part three, the legal issues around the issues of electoral technology. The question of technology will be dealt with by my colleague Jim Otieno. But my overall comment here is to compare the court's attitude to IEBC claims in 2017 and 2022, and to come to the conclusion that if you look at the court's attitude to IEBC claims on technology in 2017 and 2022, it's like day and night. And yet the differences were very stark. There were disagreements between the commissioners about the transparency and deployment and use of technology, including by the commissioner who was in charge of technology. There were disagreement about what the scrutiny revealed in this particular case. There was a presumption in 2022 that the IEBC actions were valid based on untested affidavit advice on both sides. The Supreme Court did not test anybody's affidavit. Did not allow opportunity for testing anybody's affidavit. And the usual response by the Supreme Court on this question is that the time constraints. And of course, there are time constraints. But we should not get to a situation where time constraints have become the basis on which every fundamental constitutional principle is suffering. Either it is underinterpreted or not getting the hearing that it deserves to get, because we are all worried about time constraints. Now, what are the requirements of the use of technology in our law? The requirements are in Section 44 of the Elections Act, and the IEBC is required to have an integrated electoral system that enables biometric voter registration, electronic voter identification, electronic transmission of results, etc., etc., etc. However, electronic transmission is limited to the presidential election. The section also requires IEBC to develop their own manner of issues. Now, what are the findings of the court on this? The court's central finding on the register of voters was that the KPMG audit report was released to the public 7 days before the 9th of August, and that the register of voters was used at the elections as a medium for identification of voters without any apparent anomalies. This finding cannot stand scrutiny. Section 27 of the IEBC Act requires the Commission to publish and publicize all important information within its mandate affecting the nation. The 2017 audit was not published. The 2022 audit was not published. The 2022 audit, they published a very heavily edited PowerPoint presentation that excluded all the major areas in which in 2017 KPMG had found serious issues. So that cannot amount to a publication, to a fulfillment of the obligation under Section 27, 1 of the IEBC Act on any reading but the most lenient reading. Concealing audit findings, the second point, concealing audit findings on the register is a serious violation of Article 35, 1B of the Constitution, which gives every citizen a right to access information held by another person required for the exercise or protection of any right of fundamental freedom. Their access to the register in its true form, in terms of whether it has integrity, whether it can be hacked, etc., etc., is information required to exercise the right to vote. There is no doubt about it. So, to the extent that this information is withheld, it's a violation of that article. So that we can then say confidently that the duty to release information required to exercise the right within the meaning of Article 35 has been violated. The duty to make proactive disclosure of information of national importance under Section 27, 1 of the IEBC Act has been violated too. So it cannot be unproblematic. This finding that this was compliant is completely unproblematic. Now, the court's conclusion that the IEBC has remedied the defects identified by KPMG audit is also not credible. And that's for the following reasons. Many of the defects identified in 2017 were still unremedied in 2022. First, inadequate authentication and testing and insufficient auditability, defective database controls and infrastructure insecurity, a weak security governance framework, inadequate continuity controls, insufficient redundancy in the network. You see, when you see an aeroplane, a Boeing 737 flying on 2 engines, it can fly on one. It flies on 2 because you build in redundancy. The system must fail safe. If the system fails, it fails safe. That's why it has to, whatever. So the system audited in 2017, it didn't have redundancy. Audited in 2022, didn't have redundancy. Insufficient user acceptance documentation, system vulnerabilities, including unauthorized access. Now, that's first why the finding is not credible. The second reason why the finding that IEBC has remedied the defects, why it's not credible, is something I actually owe to Kwamchati Makoha. Given how late in the day the audit was completed, some of its more glaring defects, like duplication of records, and at the time of the audit, more than 471,000 records had been duplicated. In terms of defects, in terms of duplication, the way you deal with duplication in biometric systems is what is called a biometric deduplication. And a biometric deduplication entails you collecting the biometrics of every voter and then running them against the records you have so that you can deduplicate. Now, let me show you why it's not plausible that the IEBC could have remedied the defect. The final audit was presented, I think, on the 22nd of June, thereabouts, on 22nd of June. Now, consider this. Each voter has 10 fingerprints. In a database of 22 million voters, there are 222 fingerprint data references against which to check each of the 10 fingers. Actually, you have 8 fingers and 2 thumbs. To verify the fingers of one voter entails 2.2 billion checks. Did IEBC, in the heat of preparing for an election, set time aside to deduplicate? We know they didn't collect the duplication, the biometrics. So even if they were deduplicating, they were not deduplicating on the basis of freshly collected biometrics. Okay? Now, so that is the reason why I think the finding that they had remedied the defect is not credible. The Supreme Court also found that the IEBC had publicly tested the technology that it deployed in the August 9 election. In fact, the only public testing IEBC conducted was inadequate, and it failed. It was inadequate because it only tested performance. When you test technology, there are a whole variety of tests, acceptance testing. Is this what we ordered? Yeah? Robustness testing. How well does this thing cope with stress? Stress because, maybe storage, maybe not enough cooling equipment in there. Yeah? Auditability, usability, all those tests. None of these were conducted so far as I'm aware. And in fact, I was in a meeting with IEBC, or IEBC was in this meeting in Diani, and when the issue of the failure of the test was raised, IEBC said that the system worked after the media left. That was the response. So which I found the technology that like being spied on. Part four, burden and standard of proof. Now this is going to be quite technical, so I want to warn you in advance. Now I'll try and make this as simple as possible. Now, first of all, let's begin with some language in the Malawi decision that I think is really important. There seems to be an attitude in our jurisprudence that people want to file petitions. And people want to file petitions, want to nullify elections. There seems to be a sort of, it's unstated, but it seems to be run through our jurisprudence. In the Chilima case, the court said, challenging an election result, especially the presidential election, is not a light matter. That's number one. Number two, the electoral management body will not get everything right. That's, again, I grant that. Number three, the court should be alive to the consequences of nullification. Even so, the Chilima court continued, in a constitutional democracy, nothing perches itself above and beyond legal scrutiny, judicial review, and such other relevant processes that are intended to ensure the supremacy of the very constitutions and laws upon which democratic values are affirmed. In other words, the Supreme Court of Appeal in Malawi is not approaching this issue lightly, the question of burden of proof and standard of proof. It's not approaching it lightly. It's recognizing the weighty nature of a presidential petition in a constitutional democracy. Okay? Now, and most important, the court said this, which I am going to apply throughout my argument. It is the commission that has custody and control of all the official material that it has generated in the course of conducting the election. We think that these factors should have a bearing on questions of burden of proof and standard of proof in elections litigation in our jurisdiction. Underline that. It is the commission that has custody and control of all the official material that has been generated in the course of conducting the election, and the court thinks that this fact should have a bearing on questions of burden of proof and standard of proof in election petition. The burden of proof generally is based on a very simple idea. It is the person who alleges must prove. If I bring you to court, I'm the one making these claims about you. So it's a fair point. Prove. But at what point do I discharge that burden so that the court can then say, you have done as much as I think you should do at this stage. It is now the turn of the guy you have sued to answer. That's what the standard of proof is about. The standard of proof is about once you have come to court, the court has to determine, now that you are giving us facts, which according to you prove that Wachira has wronged you. At what point does the court say, you have actually shown us that Wachira has actually wronged you, and it's now time for Wachira to answer? That point is what the standard of proof is about. Okay? That point at which the court says, now it's the turn of Wachira to respond to you. That's what the standard of proof is about. Now, there are two standards there are two general standards in law. Okay? The first is the civil standard. The civil standard is, we say you prove on a balance of probabilities. Let me explain what this means. You have two theories or two probable explanations for something. The question that the court faces when it talks about a balance of probabilities, it is that I have said, as a guy who brought you to court, I have said, these are the facts that show that so-and-so has wronged me. You have now been asked by the court to respond to me. And you have also said, this is evidence that I have not wronged Wachira. So there are two possible explanations before the court. There is my explanation, the person who sued you, and there is your explanation, the person who has been sued. So both stories are probable as an explanation of the state of affairs. So in civil cases, the court decides which of the two explanations is more likely. That's why it's called a balance of probabilities. There are two probable explanations. Which of the two explanations is more likely to be true? Okay. The second standard is in criminal cases, and it is proof beyond reasonable doubt. This means that there is no other reasonable explanation for the state of affairs that is before the court. Underline a reasonable explanation, because you can have all manner of unreasonable explanations. But there is no other reasonable explanation for the state of affairs before the court other than the guilt of the person who is before the court. Now, so in Malawi, they have said that the standard of proof in election petitions is like that in civil cases. In other words, given two explanations, the Electoral Commission explanation and the petitioner's explanation, the court decides which of the two explanations is most probably correct. In Kenya, we have said that in certain instances involving what they call statistics, instances involving statistics, you must prove beyond reasonable doubt. And instances involving claims that an election offense has been committed, you must also prove beyond reasonable doubt. Okay? Now, the question, and then they have said that in other cases, the standard of proof is intermediate. It's between balance of probability and beyond reasonable doubt. My first question is, pray, what is the midway point between these two positions? My conclusion is, this standard is both unprincipled and incommensurable. You can't measure it. And it's unprincipled. You cannot say what its content is. And you cannot measure how far between the balance of probability and beyond reasonable doubt where it lies. It seems that you have a number line. And this is to be determined where the number line, the point is to be determined by the mood of the judge. It could be closer to, because it's intermediate. Is it exactly halfway? And what is the halfway point? What is the content of the halfway point? Okay? Now, so that's the first problem I have with it. Because in my view, it gives any court a free-floating right to swing between the pendulum between any of those 2 points. Because it's a matter of discretion where you draw the line. I think it's clear what a balance of probability means, and it's clear what beyond reasonable doubt means. I am not clear what the intermediate, and if anybody knows where this point is, I would happily be guided by you in terms of where that position could be. That's the first problem I have with this standard of proof that we have articulated. The second problem I have is, what is the point of shifting the standard of proof when allegations of crime are involved? What is the point? The issue before the court is not a criminal trial. Yeah? A petitioner's allegation that a crime has been committed cannot lead to a conviction. And why can't it lead to a conviction? Because every person accused of an offense has a right of confrontation. You're supposed to confront your accusers and say what you have just said is not true for the following reasons, and you are lying, and you cross-examine, and you do whatnot. You're supposed to do all those things. In a petition, that opportunity doesn't exist. So why would you burden a petitioner by saying they must prove beyond reasonable doubt on a thing which they could not possibly do because it is not available? That option is not available to in the petition in the case before the court. I mean, if it was a case in which the petitioner would, in which the other side or whoever is being accused of a crime is given the opportunity to cross-examine, to call evidence in his favor, if it was like that, then you can see why you would say proof beyond reasonable doubt. Okay? Without a right of confrontation, it is useless to establish a standard called to prove anything beyond reasonable doubt. That's number one. Number two, in the absence of confrontation, the most a petitioner can establish is prima facie. The most I can, if the party I'm accusing of a crime doesn't have a right to confront me because that is not the forum, the most I can actually establish in a petition is that there is prima facie evidence that a crime has been committed, which then goes back to balance of probabilities. Because that's how you establish a prima facie case. You go back to balance of probabilities. Okay? So it follows, in my argument, that the court's requirement that a petitioner who alleges a crime has been committed in the course of the election must prove beyond reasonable doubt. It follows that proving that the crime was actually committed is logically impossible. So you basically have established a standard which nobody can meet, no matter what they do, even if they are well-meaning. They cannot meet it. Number three, I want to deal with this question of Article 138.4, where they talk about statistics. If I could have some water, please. Where they talk about statistics. Sub-Article 138.4 says that the winner of a presidential election must win more than half of the votes cast, 50% plus 1, and at least 25% of the votes cast in more than 24 or more of the counties. It is difficult again to see how a petitioner can prove beyond reasonable doubt that the requirements of Article 138.4 have been met, unless the petitioner also has a right to cross-examine IEBC. Because what is going to happen is the following. You claim that the requirements haven't been met. IEBC will claim in return that they have been met. Okay? None of you has a right to cross-examine the other because this is being tried on affidavit evidence. So pray, how is it that you're going to establish beyond reasonable doubt that the provisions have been met? How? The other guy doesn't have a duty to come to the stand to be asked questions by you or to ask you questions. Yeah? Where the IEBC's affidavit are accepted on the face of it, as it was the case in this particular case, the claims cannot be scrutinized, what it says cannot be scrutinized, and the court must then choose which numbers to believe on a balance of probabilities. You have claimed, I have claimed. No one has a right to cross-examine the other person. So the only basis the court has for determining who to believe is on a balance of probabilities. Unless the court says, in these situations, we will always ask IEBC or the petitioner to come to the stand to be questioned and cross-examined and to call witnesses. Okay? Now, so that is number three, the criticism of this standard of proof. The fourth and final criticism of this standard of proof is that this standard of proof is deeply unjust and completely flies in the face of the principle of equality of arms inherent in any civilized notion of a fair trial. Why do I say this? Equality of arms is a principle in international human rights, it's actually international human rights law relating to fair trial. And it's about a fair balance between the parties in court. It means certain specific things. First, some of the things it means. First, each party must be afforded reasonable opportunity to present his or her case without any substantial disadvantage vis-a-vis the other party. That's the first thing. The second thing, each party should have the possibility to access any information held by a public authority, especially when that public authority is the authority that such a party is suing. Okay? In this case, most of the information and evidence that a petitioner needs to press his or her claim is held by the agency committing the malpractice. Okay? The IEBC is the agency that manages elections, but it's also the agency that has custodian of that information. Number three, it is also the agency that regulates who has access to that information. So it combines three roles that are in conflict. The role of manager, custodian, and regulator. Okay? It combines three functions that are in conflict. So if such a body, in its role as a party before the court, uses its power as custodian to block access to that information by the person suing it, you can never win against it. Yeah? Because it's got two conflicting positions, and it wears the hat according to what is being asked. So if you are suing it in court, it comes to court defending the case. When you then ask for information, it wears the hat of custodian. And it says, no, you can't get access to this information. And then finally it wears the hat of a regulator and says, you must pay for it if you want to get access to it. So you've got this Kafkan nightmare of somebody has done something wrong. You want to sue them. They hold the information. They wear the hat of a custodian and say, no, you can't get it. Finally, under pressure, they say, yes, you can get it, but you must pay for it. And it's information collected with taxes. Okay, it's information paid for by taxpayers. So this is such a deep injustice. And it seems to me that the court has passed over these questions quite casually. Whenever scrutiny is being asked for IEBC service, the court restricts this access, like this last time, with language that troubled me. One of them was, some of the information requested for might raise proprietary issues because this contract have been signed with other parties. Sovereign control of the democratic process means that the sovereign right to the information held by IEBC belongs to the people of Kenya. Any contract you sign that gives away people's sovereign right over the information required for their democracy must be unconstitutional. There cannot be a debate about this one. There cannot be a debate about this one. I think I think this is a profoundly disturbing question for me, because it's one of the issues that at the heart of our democracy. If the citizens cannot access information that they need to exercise their rights, what is the meaning of sovereignty? And they can't access that right because somebody who was contracted by the premier institution responsible for running elections, a private entity, foreign, has said, written to the court saying, this might raise proprietary issues. They wrote. Smartmatic did. So I think these are really profoundly disturbing questions that we need to look into. So I would want to leave the question of standard of proof with those four arguments against it. I think we have crafted a standard of proof that is raising fundamental questions of constitutional interpretation that I think need a better hearing than the court gave it. Okay. Now, given the fact that on this question of standard of proof, elections might become very unfair in the future, there's some very basic problems that I expected. You know that section of the judgment where the court says about some of the reforms that are needed? I thought to myself, if I were making that decision, what are the areas I would look at? The areas I would look at is, given the conflict, the role conflict between IEBC as manager, IEBC as custodian, and IEBC as regulator, the first thing I would like to have is clear indication of who should have custody of the election results for the purposes of petitions and the consequences for IEBC for not making those results available promptly. That's the first issue of reform that I would be interested in. Number two, I would want a clear specification of a user-friendly format in which the results should be presented so that they do not render fair trial nugatory. IEBC says, oh, Maina decision said polling station information data is final. What does it do? It collects all the polling station data and uploads it as polling station data, 42,000 of them. If you want to find out how many people in Kenya voted for the president versus other elections, you then must get all that information into a database, which is stored in PDF, so not downloadable. So you must get that information, convert it into usable format, put it in Excel, and run the data analysis yourself. What happened to the idea that access to justice should be cheap? Election petitions are not exempted. So there must be an obligation on public institutions about the format in which documentation required for the documentation produced for public consumption are actually usable by the public. The Auditor General used to do this in the early 90s. The presentation of the audit report was opaque. It was so difficult to figure out that the government is doing something wrong. I ran an NGO in which we did an analysis of Auditor General's report for 7 years. And we had to hire 3 accountants, and they sat down for nearly a month going through those reports in order to see the fraud. But if you said this is how the new auditors have been putting the information out in very consumable form, and they should be congratulated for it. But that's what's always the case. IEBC is doing what the auditors were doing in the 90s, in the early 90s. Number three, there should be a clear spelling out of the tests and protocols for and disclosure of information around technology, definition on the rules of sovereign control by the people over election data and systems, and finally, there should be clarity what software we are using. Are we using proprietary software or are we using open source software for our elections? Now, part 5, and I'm coming to the end. I see Gladwell is getting a little fidgety. Part 5, votes cast versus valid votes cast. This issue was relitigated. I don't remember whether it was petition number 5 or petition number 6. Who raised this issue about votes? It was the Law Society of Kenya, I think, and ICJ, yeah? I think so. They wanted the court to reconsider its position in 2013, where it said that a vote is either valid or invalid. And this is what the court said in this particular case, that an invalid vote, about this issue, said it is a vote it is not only rejected, but it is invalid and confers no electoral advantage upon any candidate. In paragraph 283, it says, in that sense, the rejected vote is void. This leads to the crucial question in petition number 3, case number 3. Why should such a vote or ballot paper, which is incapable of conferring upon any candidate a numerical advantage, be made the basis of computing percentage accumulations of votes? I think that this formulation of the problem impoverishes the right to vote. And I said this in 2013, and I wrote about it in the East African. Because it seems what the court is saying, that if a vote should only count if it's capable of conferring upon a candidate a numerical advantage. And that only then should it be a basis for computing percentage accumulations of the vote. Now, the purpose of a vote, this is how I think it impoverishes the right to vote, is not to confer an electoral advantage on any candidate. That's not the purpose of a vote. It is to express a voter's wish. And the voter's wish might be to reject all the candidates, not to confer an advantage on any. In 2013, I actually spoiled my ballot because I did not want to vote for certain seats in Nairobi County. So I spoiled my vote deliberately, thinking that I was rejecting all the candidates on offer, only to hear the court say that my vote was useless. I woke up in the morning at 4 a.m. to go queue and vote, and then I am in exactly the same position with reference to that election as somebody who stayed at home. That cannot be the meaning of the franchise. Okay? So, a voter should be able to reject all the candidates on offer by deliberately spoiling his or her ballot. In India, I think it's in India, they have now introduced the option none of the above. We don't have that option in Kenya. And so long as we don't have the option of none of the above, the only way you can reject all the candidates is by spoiling your ballot. So I think there is a lot more thinking that needs to go into this. It's not just a matter of seeing a spoiled ballot and saying nothing turns on it. Something does turn on it in some cases. Part 6, now coming towards the end. Illegalities versus irregularities. And I'm saying here an old problem returns. In 2017, the way the court formulated the problem of illegality versus irregularities came very close to what I think is the correct position. But they have gone back to the position in 2013, very subtly in the language they have used. This is what they say. First, the court begins by properly identifying the issue in play. It says this: the difference between irregularities and illegality. In Raila 2017, the court defined illegalities as breaches of the substance of specific law, end of quote, and defined irregularities as the violation of specific regulations and administrative arrangements, something less substantial than the violation of the law. Now, that is as close as you can get to defining the difference between illegality and irregularities. But in paragraph 284, the court then misframes the issue, just as it had misframed it in Raila Odinga 2013. This is how it frames it, which I consider misframing. The question we pose is, quote, whether there were illegalities and irregularities of such a magnitude as to affect the final result declared in the presidential election of 2022. That's a misframing. Why is a misframing? What needs to be proved to the standard the court described depends on whether one is saying that there were irregularities and errors or whether one is saying there were illegalities. The standard of proof crucially depends on whether you are saying there were irregularities and errors or whether you are saying there were illegalities. And let me explain why that is so. Errors and irregularities. If your election is based on errors, your petition is based on errors and irregularities, you must show that those errors and irregularities have substantially affected the result. In other words, the statistical effect on the result must be proven in the case of errors and irregularities. The election itself may have substantially complied with the law. Are we together? That when you say there are errors and irregularities, you are not saying that there has been substantial violation of the law. You are saying that the statistical cumulativeness of the errors and irregularities would have affected the result. Affect the result is a term of art in law. It means that if you correct the errors and the irregularities you have identified, somebody else other than the person declared to have won the election would have won it. That's what affect the result means. It doesn't just mean that the winning candidate would have gotten more votes. That's not affecting the result, because the result remains. So in affecting the result, you must establish that the errors and irregularities you have pointed out, had they not existed, somebody else other than the winner would have won that election. The statistics, the numbers, this is what in Malawi they call the quantitative test. Okay? Now, in the case of illegalities, something else is going on. The petitioner must show that the illegalities were substantial, but does not need to prove that such illegalities have statistically affected the result. This is fundamental. You must show that the illegalities were substantial. The effect on the result is a deduction. The court deduces. It is not a duty on the petitioner to prove. What you need to prove is that the illegalities were substantial. For example, supposing people are intimidated, they didn't turn up to vote. You cannot count votes that were not cast. Yeah? So if I asked you statistically to establish that it can affect the result, you will never be able to prove it. But if the court sees systematically that in the stronghold of one candidate, voters were intimidated, from the last election where they had turnout of 80%, they had turnout of 20%, the court can deduce that these illegalities could have affected the result. You don't have to prove that the result was affected. But you see, if you look at the way the court has formulated the test, is that whether there were illegalities and irregularities of such a magnitude as to affect the final result declared in the presidential election of 2022. As to affect the result. Not as to be deduced to have affected the result in the case of illegalities, as to affect the result in the case of irregularities and errors. No, but both to have affected the result. That's a wrong formulation of the test. Okay? Finally, political ramifications. The key issue for the future is there any value in anyone going to court at all if these findings of the court on such fundamental questions of law remain as they are stated? That's the first question, and I think it's a really important question for us to answer as a country. Number two, what does it mean about future dispute resolution? Are people going to resolve electoral disputes as they used to do before by going to the streets? Or are they going to resolve the disputes, by sitting under a tree? Because then if you go to the standards established by the court, if you can't meet them, then you sit under the tree or you go to the streets. And the final question for me is, has the court struck what is called a Mephistophelian or Faustian bargain? Faust, Mephistopheles in Faust, in Faust, argues, Dr. Faustus argues, strikes a bargain. A Faustian bargain is a bargain where a person, you trade off something valuable, morally and ethically valuable, such as personal values or spiritual values, in return of something worldly, like knowledge, power, or riches. In the case of Mephistopheles, in the case of Faust, he struck a bargain for knowledge. Maybe the court wanted certainty. That's why they were unanimous in this matter. But has certainty come at too high a price to the law related to elections? Sorry, Gladwell, I've been on too long. Thank you. Thank you, everyone.
Thank you so much, Wachira. I think that was a really great explanation, and I really feel educated.